On the record in the matter of the people of the state of Michigan versus Frank Stevens, 22-03370, council appearance.
Luann Lemmerman, Assistant Attorney General on behalf of the people.
Grano, Assistant Attorney General on behalf of the people.
Good afternoon, Your Honor. John Moodhart on behalf of Mr. Stevens.
And Don Passenger, P39384 on behalf of Mr. Stevens as well.
Okay, and then I see Mr. Stevens is present via Zoom. Today is the date. Thank you. Today's the date and the time that was reset for another probable cause conference. How are we proceeding on this?
Your Honor, we have reached tentative plea agreement that needs to be sort of run up the flagpole, as I understand it, at the AG's office. So we're asking for a several-week adjournment so that that approval can be sought.
That's correct.
Okay. December 6th and 10. Does December 6th at 10 work?
It's a Friday, Your Honor.
Yes.
Works for Passenger.
That works for me, Ms. Lemmerman, Your Honor. Thank you.
I do have an Oakland County hearing at 9 o'clock by Zoom that day, Your Honor. Two of them, but and I don't know, you know, those hearings can be any time of day. Judge Valentine will move them around. I suppose it's as long as Mr. Passenger can make it, there's no need to.
10. Okay, you say you have a hearing at 9, you said?
At 9 o'clock in Oakland, yes, Your Honor.
Okay.
I have two hearings that day. I mean, it's really going to be, they're very similar cases, so it's really kind of like one hearing, but it's a.
If it's going to be a plea, is it going to be a felony plea, do you know, or a misdemeanor plea?
Misdemeanor plea, Your Honor, is what's anticipated. So we expect we would probably stay with your court.
Okay. What are we doing at 8:30 that day?
I have a thing at 8:30, so I'm unavailable that early.
Okay.
And we probably would schedule a plea on a different date in any event.
Okay, well, then we'll keep the PCC on for 10 o'clock. We don't really need to go on the record for it. If you all agree that we're going to continue to plead a counsel, you all can email my staff. We'll get you a plea date.
Thank you, Your Honor.
Yep, thank you to you. Thank you to you and your staff, Your Honor.
Thank you. Any additional matters for the record?
No, Your Honor.
No, Your Honor.
No.
All other conditions continue. Of course, just state on the record. Thank you.
Bond and conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. I'm just trying to find my own things. Okay, on the record in the matter of Calvary SPV versus Joy Green 24-00354. Council appearance.
Good afternoon, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And Ms. Green is here. Ms. Green, you requested an adjournment so that you could hire an attorney.
I requested an adjournment so I could seek legal counsel.
Okay, and so you sought legal counsel?
I sought legal counsel from a law firm that had sent me a letter in regards to this case. I talked to that attorney, and he was just pursuing bankruptcy, me as a client for bankruptcy. I also reached out to a friend who is a lawyer, but I have not, I didn't receive any contact back.
Okay, and so I recognize that you wanted to get an attorney, but based on your answer, it's not that you're looking for, you have a defense. You just you want to settle this for a lesser amount,
Correct.
which is not a defense, ma'am. You do recognize that.
It's what?
It's not a defense to the amount owed. You do understand that?
Right.
And so the purpose of today's hearing was a motion for summary disposition, meaning the plaintiff has filed a motion saying that judgment should enter for that amount because you have not presented a lawful defense, or just general denial of that you wanted to not pay that full amount, which is not a lawful defense. So without any other defense, I have no choice but to grant their motion, which should put a judgment in for that amount. You can later negotiate settlement of a lesser amount if you do file bankruptcy or you go through some credit company. That's something you still have the option of doing. That's nothing really to do with what's going on here today, which is there is an amount that you're being sued for, and that there was a complaint that you were served, and your answer does not dispute that you owe that amount.
Okay.
So, and you stand here today, you're not disputing that you owe that amount, correct?
I would, however, I do not dispute that. I would, however, like to file a motion for installment payments.
Okay, and so judgment in favor of the plaintiff under their motion for summary disposition on the merits of the motion. And then you want to make a motion for installment payments. You can meet with Mr. Werber to see if you all can talk about your finances, about what you should pay or what you could pay. And I'll let you all stipulate to an agreement for that. Mr. Werber, does that sound amenable for you?
Yeah, that's fine. Go ahead. Sorry, ma'am.
We have had discussion.
About what your monthly payment would be? That's what I'm gonna have you meet about right now, about the installment payment.
Prior to last time when we met.
We never spoke about a monthly payment plan, ma'am. You wanted me to accept the settlement offer made to you back in 2022 by the original creditor. I'm happy to put you on a monthly payment plan. I always have been.
Okay, and then also you had said the lesser amount of 3,300. Is that the satisfied?
No, that was only if you could make a lump sum payment. Now a judgment's being entered against you for the full balance. You're gonna have to pay the full balance, but we can discuss a monthly payment plan if that's something you want to do.
Okay, the monthly payment plan that you had stated.
Okay, let me put you in a private meeting room, because what you all talk about, I don't need to be privy to
Okay.
as it relates to how you're gonna make that happen. Mr. Werber, did you submit a judgment for the summary disposition motion?
Yes, I submitted an order, Your Honor. It's after the brief, right before the proof of service and the exhibits. You should have a copy of that.
Okay, we'll get Ms. Green on a device so that she can meet with you privately and you all can discuss the payment plan.
All right, thanks, Your Honor.
Thank you.
I have one question.
Yes.
Sorry. So if we do not come to a conclusion on a payment amount,
Then I'll make a ruling on that based on your motion. On the record, in the matter of 900 Long versus Leandraine Chapman, 24-04790. That's you, Leandre. You can come up to the table there, ma'am. Counsel, can I have your appearance?
Yes, Your Honor. Good afternoon. Ali Risk on behalf of the plaintiff.
Ma'am, you can state your name, please.
Yeah, I'm Chapman.
I'm assuming, is that our iPad? I'm not sure. Who just joined from the iPad? That's ours. Yeah. I used to have our name. Wait, this is not. We have a new one. Oh, okay. Mr. Werber, I'm gonna put you in room 1.
Thanks, Your Honor.
Okay, I'm sorry, ma'am. Leandrine Chapman. And today was the date for a motion to set aside a default judgment. Let me open the file. Okay, so this was an eviction matter. Let's see. There was a complaint. Looks like you were supposed to appear in court. On the 16th, you failed to appear.
I was here. So I came here on the 16th. My paperwork said October 16th at 1:30. When I got here, he told me that my case was dismissed. He told me to go to floor 5 and get a dismissal paper, which I did.
Who told you this?
The person down there, it was a man. He had everybody's court dates on the paper, and he said mine was dismissed at 1:30. So I went down and got a dismissal paper, which it said it was dismissed. The next day I went to my lease office and basically to see what was going on. So it was 2 cases filed against him.
You had 2 cases at the same time?
Yeah, and so one was at one.
The 2 evictions? Why does she have 2 evictions?
Your Honor, I'm only aware of the one before the court today, Your Honor. You're saying another.
Yeah, she had 2 evictions scheduled for the same date, so I'd be confused too. Motion to set aside default granted.
Your Honor, if I may make a record.
You may.
Thank you, Your Honor. So in order for a default judgment to be set aside, there not only needs to be a valid excuse as to why they missed court, but there also needs to be a meritorious defense stated. The defendant here has not stated any defense to the non-payment case. So she may have a valid excuse as to why she missed court, but there is no defense as to why she hasn't paid or this non-payment case has came about.
Yeah, I thank you for the record. Motion to set aside default is granted because she shouldn't have had 2 evictions proceeding at the same time, which means that you or your client filed another eviction and completely blew off the fact that you had another matter pending against her. And I think they both were filed by your office. They both were filed by the same office. So if I had 2 eviction matters pending and I'm a layman and I don't know what's going on, I too would be confused. So she has provided the court with sufficient good cause as to why her court date was missed. She was present, so she did not default, and her meritorious defense to the case is going to be waived because she had no business having 2 court dates on the same date. So I'm going to reset this for a pretrial so that she can appear in court and be advised of her rights as she should have been advised if she had had a pretrial, and then we can proceed to find out what her defenses are. If your office wants stand firm on the black letter of the law. It's going to start with how you're filing evictions. This is the second time in the last week that I had 2 evictions. Actually, I think one had 3 evictions filed by your office.
Okay,
The
Your
same
Honor,
defendant
I'll
3
look into that.
this week. I
I'll look into that, Your Honor.
December 4th at 8:45. It's going to be your pretrial date. You can appear for your pretrial via Zoom, okay? Long as you have a video. The pretrial, the purpose of it is to go over your rights, to see if you want to meet with legal services so that they can do an intake for free. They will do intakes to see if they can represent you at no cost to you. And then you also have the right to meet with our eviction diversion facilitator. I'll give you his information now in case you want to reach out to him in advance to see if there's any resources that could help assist you. This was for non-payment of rent or termination of tenancy. It was for non-payment of rent. And so if the balance is paid in full before your hearing date, that would include court costs, the eviction will be dismissed, okay? Do you have any questions at this time? I can't hear.
No.
Thank you. We'll get you a notice to appear. Any additional matters for the record?
No, thank you, Your Honor.
You're all set. Thank you.